Hi, everyone. Welcome to the UCLA Tribal Legal Development Clinic Brown Bag Lunch Series. I am especially excited to welcome Professors Angela Riley and Kristen Carpenter to discuss the implementation of the United Nations Declaration on the Rights of Indigenous Peoples. This is an issue that is near and dear to the clinic's heart, and as we can tell from the presence of all of you, it is important to you as well. Just as a friendly reminder, this is an open brown bag series that the clinic is offering. It was originally conceived as an opportunity for our law students to be able to talk about tribal lawyering. And because of COVID, we went digital. And as soon as we did that, we realized that maybe some additional individuals would be interested in these topics. And so here we are today. Because there are so many of us, we will predominantly be muted. However, we warmly invite you to use the chat function to ask questions, and we will be monitoring that through the event. As you saw through your consent button, this is being recorded. And with that, I would just like to welcome you. I hope you're having a great Friday. Thank you all for being here. And I'd like to turn it over to Professor Angela Riley.
Hi, everyone. Good afternoon. It's wonderful to have you all here and to see your faces. And I'm really delighted and honored to be a part of this conversation today. There's a lot going on in the world, so I hope you're all doing well as we engage here. And I want to thank Professor Van Schilfgaarde for pulling this all together. She's the director of our clinic here at the law school at UCLA, and she's done a remarkable job, so thank you. I guess I want to start by doing a brief introduction of our guest speaker today, and I hope that that siren isn't too annoying. Professor Kristen Carpenter, I don't have her bio printed out, but as many of you know, she and I have a very long history of working together, and I think I know a lot of the details at this point. Professor Carpenter is a law professor. She's a chaired professor at Colorado Law School in Boulder, Colorado. She directs the Indian law program there. She did her undergraduate studies at Dartmouth and her law degree at Harvard, which is where we met. And we're roommates and co-chairs of the Native American Law Student Association, and now, of course, colleagues and frequent co-authors. She has a long and distinguished record in academia and also in terms of advocacy for Indigenous peoples, and has really engaged very broadly at the United Nations level in recent years, most recently becoming the North American representative of the United Nations Expert Mechanism on the Rights of Indigenous Peoples, otherwise known as MRIP, and is also now currently the chair of MRIP. She's worked extensively on issues of culture and language rights in particular, as well as many other facets of Indigenous rights. So because I have this very loud beeping that's happening, Professor Carpenter, would you mind saying a few introductory words while I mute?
Thank you, Professor Riley, for the very kind introduction. I feel like I should reintroduce you since you were so generous with my background, but I know this is your venue and you're the host, but I just want to acknowledge the many ways that you've been an inspiration to me and so many people in encouraging all of us to work harder and be better and stronger with respect to Indigenous peoples' rights advocacy as scholars and lawyers and students and so on. And your own incredible track record is well known to many people, but thank you for all of the many collaborations and the chance to participate today.
Well, we're delighted to have you. And so what we have in store for you today is what we thought is that Professor Carpenter and I would kind of dialogue back and forth. I ended up getting a delivery in the middle of this that wasn't scheduled to come for a while, so I'm kind of trying to balance lots of different things here. But what we thought we would do is I'm going to do just a little bit of an introduction and then turn it over to Professor Carpenter, and we'll kind of go back and forth a bit. So as you can see, the title of the project is Implementing the UN Declaration on the Rights of Indigenous Peoples, and the actual concrete implementation portion of this presentation will be given by Professor Carpenter. This is a project that the clinic is actually working on right now in conjunction with law students at the University of Colorado Law School, and also with the Native American Rights Fund. So we're sort of partnering together a group of organizations that are devoted to thinking about actual concrete implementation mechanisms for the declaration. And in the clinic setting in particular, we're working on what we're calling a tribal toolkit. So we're really trying to advance the ball by creating materials, both written and probably also video, of which this presentation may end up being one of the resources that we provide to people to help people, and particularly tribal leaders around the country, and if relevant around the world, to think about how they themselves could begin to implement the declaration. And that leads a lot into the work that Professor Carpenter and I have done in our own research, which I'll talk about in just a minute, sort of thinking about ways that Indigenous peoples are using the declaration as a point of inspiration in combination with tribal law to really move away from colonial models. So Professor Carpenter is running my slides. So here's the first slide. So let me just say a little bit about Indigenous peoples and human rights. Professor Carpenter it was definitely the expert on this, and she'll be giving you more information. But I did want to just say a couple of things that are sort of interesting about the way Indigenous peoples' rights have developed in the international sphere. So for one thing that you might notice if you've done any work in international law and in international human rights law is that there's sort of a body of Indigenous peoples' rights that is developed in parallel to a body of minority rights. And those have some similarities, but they are not identical. And the reason, or at least one reason that they aren't identical, is because there has been a recognition in international human rights law that Indigenous peoples are a particular and special subject of concern, because Indigenous peoples have issues that are very specific to their relationships to each other as collectives and their relationship to the planet and to the earth. So just to touch on these briefly, these are some of the instruments that specifically mention Indigenous peoples' rights. You have the Convention on the Elimination of All Forms of Racial Discrimination, or CERD, the International Covenant on Civil and Political Rights. Of course, the ILO 169 is one of the more kind of prominent documents or instruments that deals with Indigenous peoples' rights. And what we've spent most of our time working on is thinking about the UN Declaration on the Rights of Indigenous Peoples, which, as you know, was passed the UN General Assembly in 2007 and was ultimately sort of signed onto finally by the United States in 2010 in the Obama administration. We were the last country in the world that signed on to it to do it. The four holdouts at the actual General Assembly in 2007 were Australia, Canada, New Zealand, and the United States. So 4 countries that have very similar colonial histories and also have a history of essentially being Indigenous peoples having been colonized by the British. So that's kind of those. So we sort of think of those as 4 settler states. Some of the work that I've done has, I would say, focused a lot on kind of the parallels between these 4 countries. Professor Carpenter, I think her work, especially with MRIP, has taken a broader, more global view. I've done a little bit of that, but she's definitely done more, and she maybe can talk a little bit about that in the Q&A as well. So maybe moving on to the next slide, one of the things that we've worked on, and I want to just say a couple of words about, is what we call the generative moment in Indigenous rights. Professor Carpenter and I wrote an article together. We've written many articles together at this point. This one is called Indigenous Peoples and the Generative Moment in Human Rights. We wrote this article a few years ago to describe what we saw happening in the field of Indigenous and human rights, which in particular was seeing this kind of dynamic relationship between Indigenous or tribal law, national, like domestic law, like US law, and international law, and how all of those, what we call sort of multiple sites of engagement, were bouncing off of each other and interacting in a dynamic way to really change and move Indigenous rights forward at all three different levels. And one of the things that inspired this project was that we were observing in Indigenous communities that many tribes were starting to think about their own governance and their own human rights obligations to their own members, as well as the obligations owed to them by the United States or whatever settler nation that they're in, under sort of within a frame of human rights norms. And one thing we saw this do was enable, to some extent, Indigenous peoples to bypass the national or domestic law, which might be rooted in very colonial concepts, like American law, for example. If you think about the doctrine of discovery and manifest destiny, and some of the big cases that, of course, define rights, Indigenous rights in our own legal system, Johnson versus McIntosh, Teton Indians, Lone Wolf, those cases that really build on a colonial legacy and reify it with a very express embracing of the concept of Indigenous peoples as inferior, as savage, as less than, as unworthy, as not understanding property rights in the same way as Western societies. So we saw some tribes really try to think about human rights without thinking about it in the context of domestic law, and Indigenous rights as formulated at the international level seem to be giving voice to that. So this is a piece, we've asked the students in the clinic to read this piece. Of course, you're more than welcome to read it if you want, and we would invite that. But what we really wanted to focus on was think about the ways that Indigenous law built on international law, and then back to Indigenous law, and then in some places, like with some of the nation states in the inter-American system, for example, actually using Indigenous law as a basis for national law to redefine property rights consistent with Indigenous rights. And we've seen that in cases like the Awastingi in Nicaragua and others. So this is really a dynamic relationship that is going on, and I feel that it's continuing to move forward. Professor Carpenter and I were just involved. MRIP actually put it on, hosted by the University of British Columbia, a seminar on international repatriation, and I was one of the speakers at that event, and there were many others. And you know, one of the things that was interesting about that is that we have a national law in the United States for repatriation, which is, of course, NAGPRA. It's an anomaly in the global structure. There aren't that many nation states that have national laws that deal with repatriation. And yet there's a whole international repatriation movement out there, and it's happening based on human rights principles and based on a recognition of the importance of the Declaration and how that's being embodied into national law, into discourse and dialogue and diplomacy. And that's another thing to really think about that I think Professor Carpenter will talk about, is that a lot of this happens in the shadow of law, but diplomacy might in some cases be as powerful as actually positive law or litigation or other sort of what we might call like actual doctrinal mechanisms of the legal structures. So with that, I think I want to pause and turn it over to Professor Carpenter to take the next step.
Thanks, Professor Riley, for the great setup and concise introduction to a really complex set of laws and interactions that characterize Indigenous peoples' involvement in the international human rights movement. Before I leave this slide, I wanted to say a little bit more about the UN Declaration on the Rights of Indigenous Peoples. And as many of you know, this was an instrument that Indigenous peoples themselves spent decades advocating for. And the instruments that Professor Riley mentioned earlier, like the Covenant on Civil and Political Rights and the Covenant to Eliminate Racial Discrimination, of course, at least in theory, apply to the situation of Indigenous peoples. But when they talk, for example, about minority rights or the rights to property and religion, equality and non-discrimination, it's often somewhat unclear how those general rights apply in the context of Indigenous peoples. And I think beginning with ILO 169 and Indigenous peoples' own increasing advocacy at the UN and elsewhere, the decision to crystallize efforts around a document that would really expressly explain how human rights play out in the Indigenous peoples context became a focal point of the human rights movement as Indigenous peoples were participating in it. So one of the things I think that's very powerful as we move into the implementation phase is that this is a declaration that was hard fought, negotiated, and really accomplished by Indigenous peoples themselves. This is not a document that was generated by states who thought they knew better about what Indigenous people were seeking. And so it recognizes the self-determination, equality, non-discrimination of Indigenous peoples, and it also recognizes certain particularized aspects, for example, that their religious freedom involves access to sacred sites, or that their cultural rights involve the revitalization and use of Indigenous languages, and a number of other provisions that really speak particularly to their situation. And so as Professor Riley outlined, and the rest of this talk will follow this structure, we see implementation at these different levels: international, national, Indigenous, and it's important to spotlight each one, but also to understand how they interact with one another. So I'll say a few words about implementation of the declaration in international venues itself. And as Professor Riley mentioned, I am spending a lot of my time at the UN with the Expert Mechanism on the Rights of Indigenous Peoples. And that's one of 4 Indigenous peoples mechanisms at the United Nations that are specifically devoted to Indigenous peoples issues. They are MRIP, the UN Permanent Forum on Indigenous Issues, the Special Rapporteur on the Rights of Indigenous Peoples, and the Voluntary Fund, which provides support for Indigenous peoples to attend some of these events and meetings. And so the very creation of these mechanisms, which gives Indigenous peoples a venue, a set of meetings, a more relaxed set of criteria to participate in UN events, is one of the critical aspects of all of this when it comes to implementation, because Indigenous peoples currently assert and currently have some seats at the table with respect to the UN. There's also a very important movement to enhance Indigenous peoples' participation at the UN. And this is a slightly different aspect than creation of the Indigenous peoples mechanisms, because this speaks to Indigenous peoples' desire to participate through their own representative institutions at the United Nations. And I think one challenging aspect of participating in this international movement is that the UN primarily is a state-centric organization. International law is, by definition, at least formally, the interaction of nation states. And human rights law traditionally came about to protect individual rights vis-a-vis the nation state. So where do Indigenous peoples, as such, fit into that structure? A lot of Indigenous peoples have said, unsurprisingly, that their interests are not well represented by states, and they're not well represented by individuals, and they're not well represented by NGOs, and they would like to participate, for example, as the Cherokee Nation or as the Sami Parliament in the UN. They can participate in the Indigenous peoples mechanisms, but they can't, for example, before ECOSOC or the Human Rights Committee. And so those are some aspects that people are working on. There's also work with the treaty bodies, and I'm going to try not to be too technical about this, but those instruments that Professor Riley mentioned, for example, the International Covenant on Civil and Political Rights, each of those has a monitoring body, because those are formal treaties under which individuals, groups can make complaints against states. And one of the things that MRIP and other bodies have really tried to do is to say, when the Human Rights Committee is hearing a case that involves Indigenous peoples, for example, they recently had one from the Sami Parliament in Finland, the Human Rights Committee should apply the International Covenant on Civil and Political Rights in a way that uses the Declaration on the Rights of Indigenous Peoples to contextualize the case. And so when you're talking about a general right, in that case it was to political participation, the Human Rights Committee really needs to understand what political participation means to Indigenous peoples. Again, vis-a-vis their own laws, customs, and traditions, some of the historical inequities they've suffered, and also their own representative institutions again. With respect to UN agencies, and again, the UN structure can be opaque in some ways, but there are these particularized agencies that have to do with culture or intellectual property or health or agriculture, and each of those has a subject matter concern with respect to international law. So UNESCO, for example, is working on language issues and arts and culture and repatriation, as Professor Riley mentioned. And one of the things that we and other mechanisms have tried to do, again, is to say, okay, when you specialized agency, UNESCO, are working on a subject matter that interacts with Indigenous peoples' concerns, you should use the Declaration on the Rights of Indigenous Peoples to understand those concerns in context. And so, for example, there's a 1970 convention on the prevention of illicit trafficking in cultural property, but how does that play out in the Indigenous peoples' context? Looking at the UN Declaration on the Rights of Indigenous Peoples, Articles 11 and 12, that speak to the removal and repatriation of human remains and ceremonial objects, can provide a lot of guidance. And I could make the same sort of claim with respect to some of these other agencies. So in all of these ways, and in some ways, I should say, the work is enormous. We're talking about a huge institution, the United Nations, and many regional institutions like the Organization of American States, where general instruments of international and regional law are applied to Indigenous peoples, and we're trying to make them more responsive by invoking the Declaration in the application of them. So let's switch gears a little bit to the United States, and hopefully you can picture that diagram that Professor Riley had up. So we have international law, national law, Indigenous law. So here we are at the national setting. And there is a very strong and growing movement to implement the Declaration on the Rights of Indigenous Peoples in the US. And you see quotes from some of the national leaders about the importance worldwide and the importance nationally of this effort. And so as Walter Echohawk says, and he has this wonderful book that I commend to all of you, I know he was recently at UCLA, the Declaration has the promise to shape humanity in this post-colonial age that Professor Riley was talking about. Well, what would that mean in the United States? There's so much potential. We have this legacy of federal Indian law that in some ways does protect tribal rights, but in some ways is still the legacy of a previous age. It still doesn't protect tribal rights to property in the same way as non-Indian rights to property. It still doesn't protect tribal rights to religion in the same way as non-tribal rights to religion. And so these are areas that Walter Echohawk says are ripe for reform. And the Declaration on the Rights of Indigenous Peoples, by showing the minimum standards that 148 nations have agreed to, can really help with respect to understanding the appropriate standards for today. For example, when we talk about religious freedom, it absolutely must be the case that for American Indians, that includes the right to access and protect their sacred sites. Turning to Jim Anaya's statement, he talks about guiding reconciliation between the United States and Indigenous peoples. And this is something I've been thinking quite a lot about in the last couple of weeks, where our society is so clearly and so painfully still struggling with its original wounds, with slavery, with the dispossession of Indian lands. In many ways, we really haven't fully accounted for, much less been able to reconcile those historical events, and they're impacting and they're hurting us today. And I think the Declaration is one set of guidelines for reconciliation, and there's a lot of work along those lines. Turning even more specifically to pragmatic advocacy, John Echohawk has talked about tribal leaders really pushing President Obama to express the United States' support for the Declaration on the theory that it would help tribes prevail in judicial, legislative, and administrative advocacy. And of course, as the leader of the nation's most prominent Indigenous rights litigation firm, John Echohawk is keenly concerned with these issues. And to the extent that sometimes we hit roadblocks in the courts or in the Congress or in the agencies, the Declaration, again, can open our eyes to more creative, more innovative, and more globally salient standards that could help advocacy in these regards. And I'll share some specific examples on the forthcoming slides. I also wanted to mention that it's not just the national leaders who are calling for implementation. And it really is tribal leaders and tribes and tribal institutions themselves. And I think this goes to the point that Professor Riley and I were making earlier, that the UN Declaration on the Rights of Indigenous Peoples is a document that was pushed for, created by, and ultimately passed through the advocacy of Indigenous peoples themselves. And so I love this point from the Navajo Nation's Human Rights Commission, noting that because the Navajo Nation expended such a large amount of energy, time, and resources to advocate for this declaration, it's committing itself to implementation. And it's committing itself to implementation, I think, not just in the national or international settings that we've talked about, but in the tribal community itself. And the commission calls for the declaration to be made part of Navajo written law. And the Navajo Nation Human Rights Commission, and I commend all of you to their website, is, from my perspective, a really powerful institution that is using the declaration, the other aspects of international human rights law, federal Indian law, as well as Navajo law, really to push human rights and relationships in a way that reflect the best values of human existence and the best hopes and aspirations of Indigenous peoples to live in freedom and to live in good relationship with one another. And I will come back to them again too. Another tribe that's really been on the forefront of calling for implementation is the Muskogee Creek Nation. And again, I think the words used here are important. The Muskogee Creek District Court has led a lot of this advocacy through its Chief Judge, Greg Bigler, and it notes that the declaration recognizes as human rights the Creek Nation's own concerns about tribal courts, the elderly, children, violence against women, land, health, and so on. So again, the declaration doesn't impose an agenda on tribal courts or on tribal nations as much as it reflects many of their own aspirations and values. And this idea that the declaration can especially help the ceremonial leaders to protect their culture, their inherent right to exist according to Indigenous values. Taking all of this into account, the incredibly powerful international movement, some of the national challenges, and most importantly, the human rights aspirations of Indigenous peoples themselves, the University of Colorado Law School, where I'm a professor, and the Native American Rights Fund have established a joint project to implement the Declaration on the Rights of Indigenous Peoples in the United States. And so we are heeding that call that Indigenous peoples around the world are participating in. We're joining the global movement to implement the Declaration right here in the United States. And our goal is always to be led by Indigenous people, and to work specifically and concretely and pragmatically on legal reform in the United States. And to recognize that the Declaration is just one tool, but it's a really powerful one in terms of setting standards for the just treatment, legal rights, and relationships of Indigenous peoples. And I do want to pause on this point just for a moment, the idea of rights and relationships. A number of Indigenous people, I think, have rightly pointed out that the entire human rights movement reflects the language of international law and of a philosophy that has a lot of its origin in a European or at least Western legal system, and the idea of the individual as having a set of concerns and autonomy interests that need to be protected vis-a-vis the state. Now, in some ways, that concept of human rights is not intuitive to Indigenous peoples who often think of themselves not as isolated individuals, but as existing in relationship with other people, other family members, other clan members, the entire tribe, and also the natural world around them. And much of Indigenous peoples' own law, customs, and traditions has to do with keeping in balance the relationship among Indigenous peoples in their own settings with other people, and again, with elements of the natural world. And the Declaration itself, I think, recognizes this. It talks not only about rights, but about obligations of Indigenous peoples to other generations, to the natural world. And I think that the Declaration, again, when it's interpreted through some of those bodies of law, let's say the Navajo natural law or the law and custom of the ceremonial grounds in Oklahoma, it really can animate and give life to those concepts. And certainly in our project, that's an important element. So when it turns to some specific examples of national implementation in the United States, there are some important ones, and I'd like to touch on them. As Professor Riley mentioned, in 2010, the United States finally expressed its support for the Declaration on the Rights of Indigenous Peoples, and so it is now counted among the 148 nations that supports the Declaration. In the President's own statement and a subsequent statement by the State Department, there was a call for the executive branch and agencies in particular to reform their policy to be consistent with the Declaration on the Rights of Indigenous Peoples. And some agencies followed suit in subsequent years. So the Advisory Council on Historic Preservation, which has a leading role in the management of sacred sites under the National Historic Preservation Act and the consultation process with tribes, has adopted the Declaration as a guiding instrument for its interaction, both substantive and procedural, with tribal nations. And I should say the Advisory Council has really taken a leadership role in convening other agencies to think about implementing the Declaration itself. I attended a really powerful meeting Valerie Hauser at the Advisory Council put together last year in conjunction with the Permanent Forum, and she had gathered other agencies, including the Environmental Protection Agency, the Forest Service, and others to talk about their own work to embrace and implement the Declaration. And one of the things that I and students are working on now is to gather all of those policy statements that impact the day-to-day application of policy and are now able to embrace the Declaration when it comes to, for example, moving from a check-the-box approach to consultation to more meaningful, free, prior, and informed consent, or respecting Indigenous people's traditional knowledge in environmental policy. But it's not just the executive branch that has begun to implement the Declaration. There is at least one substantive discussion of the Declaration in a federal district court case, Pueblo of Jimenez versus US. And that's in the discussion of the status of Aboriginal title, which was alluded to by Professor Riley. And again, this wasn't the ultimate disposition of the case. It was a review of the motion practice, but still this is a building block. It's a federal district court citing the Declaration on the Rights of Indigenous Peoples in the context of property rights, where the United States remains an outlier. At the same time, there are many briefs, hopefully that will lead to further opinions, like the Jimenez case, where I and many other lawyers have called for the use of the Declaration in cases ranging from Indian Child Welfare Act to sacred sites to the right of tribes to determine their own membership in ways that hopefully bolster existing federal law. With respect to Congress, I think it's safe to say that we're still in the progress of determining what the strategy should be. And here I would mention two examples that I've encountered in my international work. And so Canada, for example, has kind of taken a two-pronged approach. There was a very strong bill that didn't ultimately get adopted, but was on the verge to require Canadian federal law to meet the standards articulated in the Declaration across the board. That is essentially to comply with all 46 articles of the Declaration on the Rights of Indigenous Peoples. Now, that didn't ultimately pass, but what has passed is a number of more particularized subject matter area approaches where legislation calling for Canada's Indian Child Welfare Act, its language rights provisions, and others. I think there are at least 12 pieces of national legislation in Canada that specifically invoke the Declaration and call for compliance, at least with those minimum standards. In New Zealand, MRIP got a really interesting request, and it turned into a very successful engagement, where the Maori people, together with the state, the national government, asked MRIP to come help develop a national implementation plan for the Declaration on the Rights of Indigenous Peoples. Now, this isn't yet a legislative measure, but it's a programmatic strategy together with Indigenous peoples and with the state to implement the Declaration. And even while we don't have either quite yet in the United States, and we may be moving toward that, especially as the political winds are shifting, there have been a number of pieces of testimony given before Congress. Matthew Fletcher has done one with respect to land rights that have invoked the Declaration on the Rights of Indigenous Peoples. I'll point to just a few tribal examples and then pass the mic back to my partner in crime, Professor Riley. So again, imagine that graphic, right? We have international implementation, national implementation, and tribal implementation. So here we are in the tribal setting. I already mentioned the Navajo Nation Human Rights Commission, and I think it really, again, is an institution I would like to hold up, and they have an amazing website that you can search for more information. But I've been inspired to see the commission use the Declaration to deal both with local issues in reports and hearings on race relations, water issues, sacred sites, and in international advocacy. And so the Navajo Nation Human Rights Commission has written petitions and statements and submissions to the UN Special Rapporteur, to the Inter-American Commission, and it's pursuing advocacy at all levels. And in its use of the Declaration, every single time that I have seen, it has gone back and forth between English and the Navajo language, between international, federal, and tribal law and Navajo natural law to describe things like water rights. What do water rights mean to the Navajo people? And I think that's a really powerful, and as we said in our article, generative way to allow tribal values to give life to the Declaration. A number of tribes have resolutions, and they call for various things. Some of them support the UN's adoption of the Declaration on the Rights of Indigenous Peoples. Some of them call for the United States to implement the Declaration, and others call for tribal law to embrace the Declaration itself. And with our students, I think we're trying to gather all of these so that we can kind of have a sense of how, why, where our tribes are doing this kind of work. Going back to the Muskogee tribe, they've done a really interesting thing where, inspired by the UN Declaration, they have drafted a Muskogee Declaration on the Rights of Indigenous Peoples that they call MDRIP, after the UN DRIP. And they have adopted it as a matter of tribal law, so it's binding in tribal settings. And it both states important human rights of the Muskogee people and translates many of them into the Muskogee language so that it's truly an emblem and an expression of Muskogee law in a human rights and relationships context. With respect to repatriation, MRIP recently received a request and had a country engagement from the Yaqui people, a really powerful one in that it was a request of the Yaqui people that span the US-Mexico border with respect to a repatriation matter coming from Sweden. And we're hoping to be able to report on that publicly very soon. And I mention this because it's a matter coming from an Indigenous community, right? They had one of their ceremonial objects taken from them almost 100 years ago. And they have tried various means to recover this item. And when they brought this request to MRIP, that immediately brought the Yaqui people's own laws, customs, and traditions into the dialogue about repatriation. What are the standards for whether something was stolen or illicitly taken? Why does it need to be returned? How should it be returned? All of these aspects came into interaction with Swedish law as well as international law under some of the instruments that we've mentioned. And then finally, I'm going in chronological order here. I was very pleased to see the Shawnee Tribe of Oklahoma proclaim an International Decade of the Shawnee Language just this year. And this is going to coincide with the International Decade of Indigenous Languages that the UN General Assembly has proclaimed. And this is going to be a decade to work on implementation of Articles 13 and 14 of the Declaration that talk about and recognize Indigenous peoples' rights to use, revitalize, and pass on their Indigenous languages. And this is an issue of such incredible importance in the US and elsewhere where Indigenous languages are endangered. In many cases, Indigenous peoples have said their languages are sleeping. They need to be reawakened, and they need to be reawakened as part of the self-determination, the aspiration, and the future of Indigenous peoples' cultures, ceremonies, and ways of life. And here too is the Shawnee tribe noticing what's going on out there at the UN and bringing it into their community and using it as a tool of empowerment. In my concluding 1 minute, I wanted to acknowledge that all of these efforts, Indigenous peoples advocacy using the UN Declaration on the Rights of Indigenous Peoples and the CU NARV project to implement the declaration, of course, occur within a larger societal context. And the situation with police killings of unarmed African-American men and women in recent weeks and years, the common experience of Indigenous peoples with similar treatment, and the awareness of the corroding aspect of racism on our entire society has led us to issue a statement of solidarity and a call for the use of human rights instruments, some of the ones that we've mentioned that call for a right to life, for a right to be free from racial discrimination, that those must come to the forefront at moments like this when Indigenous peoples and other people of color are suffering. And all of this work, is enough for all of us to spend a lifetime on, and we've been very grateful to the UCLA faculty and the UCLA students for joining us in the tribal implementation work in particular. And with that, I will just leave us with this hopefully inspiring picture here of Indigenous peoples across the world acting in solidarity and in hope for the well-being of Indigenous peoples as individuals and as collectives, and in relationship with one another. Thank you.
Thank you so much, Professor Carpenter. That was remarkable, and I really appreciated you going through that. It's exciting to see some of the updates in this area since you and I worked on our project together a few years ago. I want to give the students a chance to ask questions, but I thought I would take the moderators or the audience, anyone who wants to ask a question, but I thought I would take the moderator's prerogative and just ask, you and I have had some really in-depth conversations about the implementation of the declaration, and some of the things that we've talked about are, for example, we hear sometimes advocates in our field will say things like we need to see a reversal of cases like Johnson versus McIntosh that are based on colonial concepts, racist concepts of savagery and the doctrine of discovery, and so forth. And one thing that you and I have talked about is that I think I've expressed concern about things like the possibility that overturning cases like that could undermine the trust responsibility, for example. When I have spoken with Indigenous peoples elsewhere in the world, as I know you have too, one of the things that I often hear from people is that they're very envious of a structure where our federal government holds our lands in trust for us. Because despite this colonial legacy that we're all grappling with, and despite the language of Johnson and what it's based on, the factual reality is that it does, the federal government does hold our land in trust, and maintaining that collective land base, and not only maintaining it, but expanding it in when possible. And we saw, of course, in the Obama administration, quite a bit of expansion. Creates the opportunity, of course, for territorial jurisdiction, for collective tribal life, for all kinds of things that are possible because of that sort of land status. So you and I have discussed this, and one of the questions I wanted to pose to you is whether you think that there are risks to tribal rights by reopening questions like that. If we reopen the question of what is the scope of land rights, for example, particularly with the current administration and the way the courts are moving on the political spectrum, do we run the risk of actually reducing tribal rights? Could it be the case that the Declaration, even if implemented, might afford fewer rights than what we currently have under domestic law? I wanted to hear your thoughts on that before we open it up further.
So those are, of course, great questions, $70 million questions. And I guess a few points. First of all, yes, Indigenous peoples in the US, in many, if not, though not all, I should say, what ways are well situated vis-a-vis others around the world. And I think tribes' enjoyment of territorial jurisdiction, even though it's not coextensive with reservation boundaries, is certainly one of those areas. And while some other Indigenous peoples around the world have that right and that practice, not all do. I guess with respect to the risks, I think there are points both technical and strategic. One technical point is that the Declaration sets a floor for Indigenous rights. And to the extent that states have already higher protection, which the US does in some aspects, there's nothing about the Declaration that would authorize states to reduce their existing protections for Indigenous rights. And reopening, I think, is always challenging, and there is in the US political context the potential for a lot of backlash, and I think we see that around the world too. A similar situation is happening in Brazil, perhaps even more egregious with respect to a rollback of Indigenous peoples' land rights. And I think that some of that is beyond our control, and some of it comes down to wise strategy and wise advocacy. And with respect to implementing the Declaration, I think we're in a period of strategizing and mobilizing. And on some of the really big questions, and I would put tribal governance, tribal land rights in those categories of really big questions, we do need to be careful and to choose our moments and our venues of advocacy, and also make clear what we want. And I think this is an aspect where this really has to be a movement, and a movement where people are talking to one another in different realms of advocacy. What do we want? What, as advocates, what do tribal leaders want as leaders, and tribal citizens want as citizens in terms of tribal land rights? What would it look like to be able to have both a trust responsibility that protects the tribal land base and a larger scope of jurisdiction and better opportunities for investment, and that issue that you and I have worked on? There are a lot of models out there, and I don't want to go on too far, but one example that comes to mind in Belize right now, as you know, the Maya people have really accomplished some very significant recognition of their property rights growing out of the Maya people's own law. And as they're in the process of demarcation and legislation to recognize those lands, they are working with Jim and Aya and others to articulate what a model of land rights and relationships would look like for them. And that includes aspects like jurisdiction, like sustainability, like community. And while Belize is very different from the United States, I think that opportunity and some of the models that we have here too might give advocates and members and leaders some inspiration to think through what's possible.
Thank you for that. I think we have time for a question or two. If you go to the participant button, you can raise your hand and I will see if I can master this function. And if not, you can just unmute yourself and say, I have a question. It looks like Ryan Garcia has a question.
Hi, so thank you, Professor Carpenter and Professor Riley, for all your work on this project, and I'm really happy to be part of the team at UCLA. I just was interested because we had got, I was able to sit in on the NAGPRA group with the project, and we got to listen to Erin Sims, who's an advocate for the Akama tribe and how they dealt with the repatriation of the Akama Shield recently. And one of the questions I asked him, because they specifically strategized that repatriation not through NAGPRA but through ARPA, which was really interesting to me. But I asked him why they didn't really include an UNDRIP implementation in that particular case, and it seemed like the biggest reason why was that there was political reluctance on behalf of the tribe to use UNDRIP due to the current administration, like the fear of reactionary statements or words or policies. And so I'm just wondering specifically in the current moment what that conversation has been like, and if there's tribes that are strategizing and waiting to implement until a different administration, or just kind of wondering what those conversations have been. Thank you.
Thanks, Ryan, for the question and for your good work on this topic. I think the short answer is yes, that tribes are being very thoughtful about, as Professor Riley called it, the risks of invoking the UN Declaration on the Rights of Indigenous Peoples or any international human rights law, given this administration's current posture towards international law. And one consideration strategically, I think, for tribes, and it's of course a smart one, if you can accomplish something without invoking the declaration, maybe it's wiser to do that at this particular time. And if there's federal law on point, and as Professor Riley mentioned, NAGPRA and ARPA as well, those are really strong statutes. If you can accomplish what you're trying to do through those, by all means, absolutely do that. There was another repatriation where the US and Finland agreed together to repatriate items to Mesa Verde, and ultimately they did go back to the tribes. But there are many settings where federal Indian law is not doing what the tribes need, and they may indeed decide to wait to strategize both for a change in administration until they have the resources, until they've thought through some of the questions we're talking about. And I think that's all part of this movement and all really important aspects of it. So thank you.
Thank you for that, Ryan. I'm going to see any other questions. I think we have time for one more, maybe. I'm looking. Feel free to just pipe up if you do. I don't see that anyone else has a question in the current moment.
Angela, we have a question in the chat box. The FS references UNDRIP in their Tribal Relations Strategic Plan. Have you seen any examples?
So I think that refers to the Forest Service, I'm guessing. And I'm not sure if it means that and other examples of agencies, or follow-up work, yes, okay, follow-up work in the Forest Service. I have pulled as many agency examples referencing the declaration as I have had the capacity to do, and I think I have 5 or so, and several are from the same agency. And I think that's incredibly important work. And it's work that also, to me, to Angela's point, feels a little bit less risky, I guess, because even though agencies are creatures of the executive branch, the individuals who are working kind of on the ground, let's say as superintendents at the Forest Service or otherwise, those are real local folks, and they're often career folks, and they have been, they have the capacity and I think the inclination to work closely when they can. It doesn't always go as well as I'd like with Indigenous peoples. So, and I also work a lot on sacred sites cases. So I love those policies and I want to make as much of them. And in my, most optimistic hopes, I hope they create agency accommodations that end up not going to court. So we don't have to take those litigation risks down the road. So again, like Ryan's point, I can also only say yes, absolutely. I've seen some of those examples. I hope lawyers are working with them as much as possible, and that we continue to push for policy that's relevant in those first levels of decision making, where agencies have so much discretion and the law ultimately protects them in their decisions, and tribes really have at least the hope of influencing the determination. I'm going to take 1 second to make a plug for agency encounters with tribes through the consultation process to really strive for the declaration standard of free, prior, and informed consent, because that can take the mere procedural requirement to consult with the tribe, which unfortunately sometimes leads to a decision that doesn't really take into account what was learned in the consultation. It can take that recurring phenomenon that's so frustrating and turn it meaningful, like a mutual agreement about how to manage a sacred site. And there are some examples, really, really powerful ones from Bear Lodge, from Medicine Wheel. In some ways, Bear's Ears was a little bit in that model, that could make a real difference on the ground.
Thank you for that, Professor Carpenter. And I did want to just add to that one thing that has been interesting to me in my many years of doing this kind of work is that when you see people, and like you were speaking of people in agency positions where they have a lot of flexibility and a lot of discretion, in my experience, when people have actually engaged with Indigenous peoples, their minds are broadened. They really expand their ideas about Indigenous rights and tribal rights when they actually engage with Indigenous peoples, rather than in this completely abstracted out experience. And I think, it's been interesting watching the Supreme Court and Gorsuch's view on many of these Indian law cases, he's even as a very conservative justice, but being one of the only justices from the West who actually has ever had any experience with Native people. And that's just one tiny example. But, I think to the extent to which we can continue to also, even though it becomes a burden for Native people to constantly feel that they must educate non-Native people about Indigenous rights, it does actually matter, and it can make a difference, and it can really, I think, move the needle on the ground. I think we have reached the end of our time. Please join me in thanking Professor Carpenter for her outstanding presentation and all of the work that she's doing. I think there are like little virtual hand claps we can give you, Professor Carpenter. Thank you so much. And I just, do you have any concluding remarks? Did you want to say anything before we close?
Sure. Thanks to you and to Laura and to all of the students and to the incredibly esteemed audience out there. I just had a chance to look at the group. I see people who I only know from their work. I think Melody McKenzie from Hawaii and others, and I'm just humbled to be there in front of you all. So thank you. And if I got any of it wrong, please send me an email. I'll try to fix it later. So thank you. I look forward to our continuing work this summer and beyond.
Great.
Oops. Uh-oh.
I think you muted me.
Sorry. I didn't mean to.
That's okay. Any final words from you, Professor Van Schilfgaarde?
Only immense gratitude to you both for sharing all of your work and for your continued advocacy in this area. This is incredibly important, and I feel like this is a real pivot in the conversation, and so I'm honored to be a part of it.
Thank you, and thank you, Heather, for coordinating as well. All right, thank you, everyone. Be safe, be well, and until next time, take care.